Hi everyone and welcome to our webinar Family Law Overview, our services and how to access them for your clients. My name is Catherine Bowden and I'm the Communication and Community Legal Education Officer here at Legal Aid Queensland. And I'd just like to start off this webinar by running through a few housekeeping slides. So it's just a little disclaimer that we have to say that the video is for community legal education purposes only. If you can take a minute to read that, please. Okay, so we will be recording the webinar today, and that's for the purpose of uploading it to our YouTube channel, where you'll be able to share it with other community workers and rewatch it for your own professional development. So when it is published, you'll be able to head to our Information for Community Workers and Carers page on the Legal Aid Queensland website. You'll be able to see upcoming webinars there as well as the recorded webinars. I'd just like to test on our end that the technology is working. Could you raise your hand for me if you can hear us? I should also just note that with the webcam today, you will only be seeing our logo. Okay, I can see a few hands. Thank you. You're welcome to pop those back down. This is just to show you your participation today. So most of you will be listening in through mic and speakers, and you'll notice that you are muted. Please just keep yourself on mute for the duration of the webinar. If you'd like to download the handout, we've got the PowerPoint uploaded there. So you'll be able to see this in the toolbar. On the right-hand side of your screen, there's a handout section. Just expand that out and click on Family Law Overview. That's the PDF of today's PowerPoint. So the webinar will go for about 35 to 40 minutes for the presentation, after which we'll be able to answer questions. We have had some questions that came through earlier, so we'll get to those. And please do hold your questions until we call for them. So nearby the handout section, you will have seen the questions box. Just expand that out, type your question in there when we call for them. And just a reminder, please don't use any clients' names. It's just general examples only, not true examples. And make sure it's relevant to today's PowerPoint. We may or may not get time to answer them all today. So if we don't, you can use that email address there, webinars@legalaid.qld.gov.au, and we'll respond to your question after the webinar. Okay, so we're going to run a quick poll. The first one is, where is your work office located? You might be in Southeast Queensland, Far North or Regional Queensland, and I know we've got a handful of people from outside of Queensland as well. So far the majority of you are from Southeast Queensland. We've got a couple of people from outside of Queensland as well. I'll just let that run for another 10 or so seconds so we can get all responses in. Still looking at the majority of people from Southeast Queensland. Second to that, we've got a handful from Regional Queensland. I'll just keep it running because I can see a few more responses coming through. Okay, thank you for that. I'll go and share those results. You can see them too. You'll see we had 54% from Southeast Queensland, then 31% from Regional Queensland, 13% from Far North Queensland, and we've got 2% of you from outside of Queensland. We've got another poll today. We're just wondering how you would rate your own knowledge of Legal Aid Queensland, whether you feel that you have a high knowledge of our services or a good, limited or no knowledge. And if you're from outside of Queensland, if you could go ahead and select not in Queensland as well as your response, hi, good, limited or none. Okay, so that's just been launched. You should see that on your screen now. So we've actually got most of you feel that you have a good knowledge of legal aid, which is really great to hear. Second to that, a lot of you have a limited knowledge, and hopefully you'll learn a lot more today as well. Okay, and I'll share those results with you now. So 47% of you have a good knowledge, 36% have a limited knowledge. And 12% actually feel that you have a high knowledge of legal aid, which is really great to hear. So I'd like to introduce our presenter to you today from Legal Aid Queensland. Her name is Lindy Hawkins-Guy. Lindy is the acting principal lawyer and mediator in our family law services. Throw an overview with you now and run through the presentation, after which she'll call for questions at the end. So just a reminder to type those into the questions box. And if you haven't already downloaded the handout, you can do that anytime throughout the presentation. So please welcome Lindy.
Thanks, Lynn. So today we're going to be covering areas that you've really asked us to look at. So we're covering areas concerning separation, divorce, arrangements for children, dispute resolution, and time permitting some basics on property settlement. How these disputes and arrangements are regulated, and then how you can help your clients, the people you assist, in accessing these services through legal aid. So I note that there are a couple of people from outside of Queensland. It's worthy of note that my comments mainly will be in relation to the services available in Queensland. So you need to consult services in your own state. They will differ from state to state. Having said that, though, the law in this area is mainly Commonwealth. So we're looking at the Family Law Act, we're looking at Child Support Assessment Act. There are pieces of state legislation as well, for example, the domestic violence legislation, but that's such a wide and specialised area that we're not going to have time to look at that. That's a specialised presentation that we can cover another time. There are other webinars dealing with those issues. And that legislation is dealt with by various courts, and again that differs from state to state. For example, the Family Court of Western Australia have chosen not to refer their powers to the Family Court in the Commonwealth courts, and also the local magistrates' courts can exercise some limited jurisdiction in respect of these sorts of disputes as well. So most of it is done in the main centres throughout the state, but if there are matters that are particular urgency and the state courts have the capacity to deal with the dispute, then it can be done in a local court, or if there's consent of the parties. So let's look firstly at separation issues. These are the sorts of questions that we're commonly asked about when we provide legal advice to clients by phone or face-to-face. But people are invariably concerned, firstly, with whether or not they can actually leave the home. So it's important to be able to reassure clients that you're working with that they certainly can leave the home. that they're not bound to remain in a relationship or a marriage. They don't need to seek permission to leave their partner in Australia. Secondly, what can they take with them when they leave? That's often an area of some concern to clients. And very often parties are able to come to some agreement about that. In most cases, it's one of those decisions, life-altering decisions that's made jointly, and parties have a plan about who's going to leave, what's going to happen. If you don't have a plan in place, and one party needs to actually force another to leave the home, there are injunctions available through the various courts, so you can obtain that relief. And if there is domestic violence issues, that domestic violence orders are available, and special conditions can be made that require one party to leave the home and the other to remain in the home. Often parties will decide for various reasons to remain separated but under the one roof. That's a fairly common occurrence for various reasons, as I say. There's no requirement to actually put in place any official documentation relating to separation, but it's always good to encourage your clients to keep a diary so that they have information or evidence to rely upon if that's required, if they're going to be involved in court proceedings at some time in the future. That can be one of the most helpful tools when they're engaging lawyers. Always get legal advice. If you're leaving the home with children, then you're certainly entitled to take whatever you need to meet the day-to-day needs of the children. So it's perfectly acceptable to take a washing machine, beds, linen, all that sort of thing, the necessary requirements. My advice is to keep an inventory or photographs. Use your smartphone to collate that inventory. And if you can, take documents, either copies or originals of important documents, and personal belongings. So particularly anything of sentimental value, take that with you. If you're required to leave suddenly, of course, you may not have that ability to plan ahead. If you need to go into refuge, contact DB Connect and they can assist you with information and support to get you into refuge accommodation. If you don't have income to support yourself, you can apply for Centrelink. Child Support Agency can assist you with child support payments for children in your care, and you also may be eligible for maintenance orders, and we'll look at that in a little bit more detail in a future slide. If your English is limited, you can certainly ask for an interpreter to assist you. Again, it's often useful to record exchanges, use your smartphone and take photographs to enable you to rely on that evidence at a future time. Divorce in Australia is fairly straightforward. It requires parties to have been separated for a period of 12 months. You need to produce a marriage certificate or a translation made overseas. You need to be a resident. You need to establish to the court that there's no prospect of a reconciliation, that appropriate arrangements have been made for your children. Bear in mind, though, that the divorce application does not actually make any parenting orders about the children. It's simply a discrete relief that dissolves a marriage. There are statutory limitation periods in place in relation to property settlements. So once a divorce order is made, you're required to commence property settlement proceedings within a certain time frame, and that's 12 months. There are new arrangements in place with the family court to allow people to apply for divorce online now. So there's been some fairly significant changes in that area, and they're fairly recent. So that's something that you can acquaint yourself with by reference to the resources in the website. They're very user-friendly. In some instances, though, parties will need more assistance than you're able to give them. If it's a particularly complex or difficult application, or if the client has particular difficulties, suffers from particular hardship where they may not be able to proceed with the application unrepresented. So always encourage people to get legal advice around those circumstances if you think that they're not going to be able to bring the application themselves. As I say, often people misunderstand the nature of divorce. It really is the dissolution of the marriage only. No other relief is made at that time, granted at that time. Seek advice as soon as you can around separation, divorce, property settlement, children's issues. Legal Aid provides telephone legal advice. It's readily available. That number's on the screen now. Face-to-face, by telephone. We have various clinics, specialised clinics in relation to all areas of law. So always seek assistance if you're supporting someone in this area. In addition, there's various community legal centres specific to your state. If you're in Queensland, they're often located in regional areas as well, so you can access that information through the internet. Also, the Queensland Law Society can refer your clients to lawyers who have particular areas of specialty or are located in your local area. And if you're not able to access legal advice through those other avenues, then you can use one of those referrals to assist your clients further. Let's have a look now at parenting arrangements. We know from the social science that it's very important for children to continue to have a meaningful relationship with their parents when they separate, and it's important for parents to continue to share the responsibility in relation to their children. Children have a right to a safe environment and to be protected from parental conflict upon separation. So very often parents will talk about their rights in relation to parenting arrangements. It's more in relation to their responsibilities. The children, in fact, are the ones with the rights. So the law has tried as far as possible to enshrine that social science and legislate in relation to objects and primary considerations around that social science. So the paramount consideration is what's in the best interest of the children. So how do we determine that? How does the court determine that? They determine that by looking at those two primary considerations: preserving that meaningful relationship between the child and both parents, and protecting the child from physical and emotional harm. If we look at the principles then of the legislation, that's more about why these objects need to be legislated, and again that's around the rights of the children. So they have a right to know and be cared for by both their parents. They have a right to spend time and communicate with both their parents and other extended family. And parents then have those duties and responsibilities in relation to those arrangements. So that's how the law works. It also provides some additional considerations around, for example, any particular wishes that the children express, parental attitudes to their responsibilities, relationships between the child and the parents. All those additional considerations are listed in the legislation as well, but the primary ones, the main ones to be aware of, obviously. If you're working with clients in this area, you may commonly come across various terms, so it's good to have a general understanding of these terms. So what used to be referred to as custody or residence is now referred to as lives with arrangement. So an attempt to really plain language the arrangements about where a child lives, whether it's with one party or it's a shared care arrangement. Secondly, access and contact arrangements. They're now referred to as spending time with, who the child spends time with, what those arrangements look like. Parental responsibility. As we've said, parents have obligations and duties to their children, so it's a presumption that that responsibility should be shared between parents. And it's about the long-term decisions, the long-term welfare of the children. Other terms you might hear in this area of disputation, a parenting order. So a parenting order covers all of those sorts of arrangements, where the child lives, who the child spends time with, the parental responsibility issues, if it is to be shared or split between the parents. All of those issues are covered in parenting orders. Alternatively, they can be covered in a parenting plan, which is a less formal agreement signed by both parties, dated, dealing with the same sorts of matters. You might hear the term dispute resolution. That refers commonly to mediation, and we'll go on to talk about that in a little more detail. Firstly, we'll do another poll just to gauge people's understanding of the term independent children's lawyer. If you could let us know if you've come across that term in your work to date. And we can see that most people are saying yes, they have heard that term. So roughly about 2/3 of you have come across that term in your work. Let it run a bit longer or close it? Close down here. Okay, thank you for your responses there. Sorry.
So it's just, you'll just see it on your screen now, that 67% of you said yes, you have heard of an independent children's lawyer, and 33% have not.
Thank you for that. So it's a term described, or used to describe the lawyer that's appointed to assist the court in determining what the best interests of the children are. So when parties can't agree on these things, an independent children's lawyer will often engage a report writer to assist them and the court, and we'll go on to talk about that in a little more detail. So the family report writer is often a psychologist or a social worker, and they're looking at those primary and additional considerations that we looked at in the previous slide, and forming recommendations to assist the court in determining what the best arrangements are for the children. So let's look at parental responsibility in a little more detail. As I said, this is it's what's called a presumption at law. So that's really our starting point, that we know from the social science this is the best option for children. It doesn't mean it's going to apply in every circumstance, though. It won't apply where there are reasonable grounds, and that's supported by evidence that the presumption, or rather parental responsibility, is it needs to go with one parent or the other for reasons of child abuse, serious family violence. Again, there needs to be significant evidence for that presumption not to apply. Like any presumption, it's also capable of being rebutted by the evidence. So if there's evidence that it's not going to be in this child's best interests for the parents to share equal parental responsibility, then the court need not make that order. For example, if there's if one parent's not able to make that sort of contribution, or if there's one parent who's historically made all of those long-term decisions about education, culture, health, religion, the other parent may have been absent for many years from the child's life. So it is capable of being rebutted, but it's important to know that that's the starting point, the legislative starting point, that that presumption will apply. So if the presumption does apply, the court says, okay, it's best for this child for parental responsibility to be shared, then the court must go on to consider whether equal time is in the best interests of this child. That does not mean, though, that equal time will be ordered. And when this legislation came into effect about 10 years ago now, that was a common misunderstanding, and we saw many, many agreements and orders where parents misunderstood. They thought they must then enter into equal time arrangements in respect of their children because of these new laws. So it's important for you to have that rudimentary understanding that really it's just a stepping stone, it's a legislative pathway to consider these issues, not necessarily order them. So if the court doesn't order equal time, then it must consider substantial or significant time for the child to spend with one or other parents. And there's really no magic in that term. It means more than what historically was ordered in relation to children, the each alternate weekend type arrangements. So substantial time would include maybe some midweek time for the child, so after school, and dinner with the parent returned that evening or the next morning to school. Weekend time, perhaps 3 out of 4 weekends, and also some holiday time for the child to spend with the absent parent. So here's another poll. If we could just ask you then to respond to whether or not you have an understanding of whether alternate dispute resolution or family dispute resolution is how it's used. Is it limited to just before you go to court? Can both parties use it subsequently through the court process? So we're getting a bit of a half-half response there. 55 is saying yes, 45 no. Thank you for your responses there. So, in fact, the answer is yes. We can. Alternate dispute resolution really covers such a wide range of processes: negotiation, counselling, conciliation, mediation, arbitration, and parties are always encouraged to use whatever is available to them. It might be an informal process, like speaking to friends, family, church, community elders, to try and help them reach an agreement if they're not able to reach the agreement on their own. But it can also be a more formal process, of course. And again, this is enshrined in law. Not only are parties encouraged to try and resolve things, but it's actually a legal requirement that you attempt mediation before you go to court. If you're able to come to an agreement, it can be formalised by way of a parenting plan or a consent order. And unless there are certain exceptions that apply, things like serious family violence, child abuse, urgency, or geographic remoteness, so that you can't actually access the services, then, as I say, it's a compulsory process. So you must then file a certificate to say that you've at least attempted that process, or it's been inappropriate for whatever reason. And if you're not, if you're relying on one of those exceptions that we talked about, then you're required to file an affidavit setting out what that exception is. So it's an affidavit of non-filing of the certificate. Most Most times formal mediation or dispute resolution is a confidential process, but not always. So it's good to assist your client in asking those questions around confidentiality. That, for example, if they're involved in court processes and they're required to consult with a family court consultant in relation to children's matters, those conversations are not confidential. A legal aid conference, the discussions are confidential. So always have that discussion just to determine your client's position in relation to mediation. And as I say, those discussions, those consultations, negotiations can continue right up until the door of the court. In fact, even after a trial is commenced, it can be adjourned to allow for those discussions to continue if there is a prospect of the matter resolving. So that it can happen at any time throughout the process. There are different models of mediation. The one we use here at Legal Aid is a lawyer-assisted process. Both parties are represented. We can provide special arrangements if there are family violence issues, separate rooms, separate buildings. The mediation can occur by phone. And some providers use what's called a child-inclusive practice. And that's particularly useful if your client has older children who are expressing particular opinions, who have that cognitive capacity. The mediator is able to engage an expert, say a social worker or a psychologist, to consult with the children, and their views and opinions then can inform the mediation so that parents have a better concept of how the dispute is impacting on the children. As I say, if you're able to resolve the matter, matters in dispute, it can be written up into a parenting plan covering all those areas of responsibility, where the child will live, etc. And the only requirements are that the plan be in writing and signed and dated by the parties. It then becomes an important piece of evidence. So the court must take into account what's in a parenting plan. If the plan breaks down and the parties are required to go to court, then the judge will take into account the content of that plan. Sometimes the plan can be used to vary a court order, unless, of course, the order actually prevents that. So an order may say that it can only be varied by subsequent order. Parenting orders, again, cover the same sorts of things, but then they're an enforceable document. So consequences flow from breach or contravention of those orders, unlike a parenting plan, which then has to be proved. So when might you want to seek a parenting order? Clearly, if you're not able to reach an agreement and enter into a plan, you might want to apply for a parenting order in circumstances where there's unlikely to be agreement. So if one party is proposing to move interstate, for example, or if the move has already occurred and one party wants to try and locate the child, the other party, and recover the child back to the state of origin, or if the move hasn't occurred, a party might want to stop the child from being taken interstate or to move to a new home. And the reason for that is that it is in breach of that primary consideration, going right back to the paramount considerations, that a child has a right to have an ongoing meaningful relationship with both parents. These sorts of arrangements would make that difficult to continue. So you're entitled to apply for a parenting order about those things. So legal aid funds alternate dispute resolution processes, but not in all cases. There are other providers, Family Relationship Centres, Relationships Australia, and the less formal avenues that we discussed as well. But if you're wanting to have a lawyer-assisted mediation, then your client must fall into the most vulnerable of categories, and it must be a substantial dispute. So the dispute must actually involve protecting the child from abuse, neglect, or on the flip side, a denial of a relationship with one or other parent. So, and the existence of the certificate, as I said, they must have attempted mediation, or mediation has not been possible, or it's been inappropriate for one of those reasons that we looked at. So it's not just about the client, it's also about the type of dispute. So legal aid will not always be available for mediation, but if you feel that you have concerns about your client's vulnerability, then the first place to start, of course, is to get some legal advice around their entitlement. And look at our online resources. Oh, I thought I'd cut that one out. I'll just skip over these ones and move on to a little bit more information about the role of the independent children's lawyer, because that's an important area where clients often need some assistance in understanding the role and communicating if they're unrepresented. So the role, as I said, of the independent children's lawyer is not to directly represent the child, but their interests. So their role is to gather information. They'll issue subpoenas to service providers associated with the family, and one of their roles is to ensure that the child's views that they're capable of expressing are put before the court. That's part of their role as well. The process is funded by Legal Aid, and another important part of their role is to commission that family report. So it's prepared by an expert social scientist. They'll interview the parties, they'll interview the children, observe them together. Sometimes they'll require to see the parties together. So if you're concerned about your client being exposed in that way with serious family violence issues, do bring that to the attention, assist your client in bringing that to the attention of either the report writer or the independent children's lawyer, so they're aware of that. They can make appropriate arrangements in respect of security for your client to participate in that process. But it's very, very important that they do participate, even if they have reservations. The family report writer is independent, expert in the area, and their recommendations will play a very important part in resolving these disputes on a final basis and on an interim basis. So let's have a look now at property matters. Property settlement really is about finalising the financial relationship. So we've looked at finalising the emotional relationship between parties when they separate, the parenting relationship, how that will be regulated. Property settlement is about those financial aspects of their relationship. So it's always good if you've finally settled this, determined that separation has occurred, that it is a final separation, to put in place arrangements for a property settlement sooner rather than later. The reason for this is that it becomes more complex as time passes. Often parties are unaware that the valuations used are those at the date of trial. So if it's been 2 years since you've separated, then your affairs will become more complex during that time frame. Always get legal advice. So there's a statutory time limit. You only have 12 months from the date of your divorce. 2 minutes to go. Okay, gather information. We've looked at that briefly. The more information you can provide to your lawyer, the better equipped they are to then provide you with advice about your the likely distribution of property, because it will be an individual determination based on a four-step process. So it's about determining what the actual pool of assets is and how the two of you have contributed to the accumulation of those assets, what your needs are going to be, what your capacity to meet those needs is, and then any adjustments that need to be made for each of you into the future. And ultimately, whether it's just and equitable to make the distribution that's sought. That's how the court approaches it, and that's how your lawyer will determine a proposal to be put to the other party. You may also be entitled to spousal maintenance, but it depends very much on the evidence whether the other party has proven capacity to contribute to your support. So you need strong evidence, and that's really a short-term order designed to allow one party to get back on their feet following separation. This is different from child support. It's spousal maintenance for the spouse to enable them to retrain them into the workforce. So seek more advice about that if you think that's a possible claim your client might have. Access legal aid through these phone numbers and the website. We provide, as I said, phone advice, face-to-face through clinics. We also have a duty lawyer service available at the courts. We provide legal advice, legal representation for mediation in relation to property where there are ancillary children's matters. We also provide a property arbitration service. So get some information about that if you think your client's going to be eligible. A raft of other areas we provide representation in, including one of the questions related to child protection. Certainly that's an area where legal aid funds, and we're getting more funding in relation to these to child protection representation currently. So always seek advice because funding may be available to represent your client. There are some other rules in relation to the to allow us to determine that the parties have in fact genuinely separated. So we require a 6-month separation unless in a circumstance of urgency. In relation to property, it's 6 months. So whilst I said it's best to get things moving as quickly as possible, if you're requiring legal aid, there is that 6-month rule. The other thing to be aware of is that legal aid is not actually free in relation to property settlement. If your client is successful and recovers a claim, then a retrospective contribution towards costs will be required. And obviously those costs are not going to be at a rate charged by private lawyers. So the rest of the slides really relate to accessing the website, and one of the most various resources that are available to provide to your clients on the areas that we've discussed today. And one of the most exciting changes of recent times is that the website now is available in various languages. So there's some information about how to convert and listen to the information on the website in various languages. So I'd encourage you to have a look at that and facilitate that for your clients as well. So that's all the time that we have available today. I do apologise for rushing through the last slides, but if you have any further questions, you're very welcome to use that feedback site that Catherine mentioned at the introduction. And shall I go to the questions now? Okay. If you have any other questions, please feel free to ask. We had a question from one of the attendees about proving change of custody arrangements. So when a child is over 15 years, they move back in with the non-custodial parent. What do you do when formal custodial parent refuses to participate in any formal or informal family law order change process. Okay. And still claims child's, I'm thinking that's child support payments, it could be Centrelink payments as well. So if you're not able to negotiate an outcome, an agreed outcome with the other party, that's when you may need to seek a parenting order. So you file a certificate to show that you've attempted to negotiate these issues, but you've been required to seek an order from the court. You're filing an application, an affidavit setting out all of those details about what steps you've taken, the fact that the child now resides with you. And the court can make that order. So I'll move on then to the next question. Working with families in child protection, child safety, as I said, definitely encourage your client to seek advice and representation. There is funding available for parents in those sorts of disputes. And we have a specialised unit here at Legal Aid that is their role to represent parents in that area. There's also direct representation available to children in those sorts of disputes as well. Well, hopefully we've provided a better understanding about issues relating to clients experiencing relationship breakdown and property settlement to some degree, some general principles there for you.